Well, good morning, everyone, and thank you for joining us here today. I am joined here today by the Principal Deputy Associate Attorney General Bill Baer, as well as Deputy Assistant Attorney General Sonia Pfaffenroth of the Antitrust Division. We are here to announce a major step in the Justice Department's ongoing work to protect the interests of American consumers and preserve competition in American markets. Now, this case dates back to July of 2015. When 4 of the so-called Big Five American health insurers announced plans to significantly consolidate the American health insurance industry. Aetna announced that it intended to acquire Humana, and Anthem announced that it intended to acquire Cigna. And we've carefully considered the impact that these acquisitions would have on the competitiveness of the multi-trillion-dollar American health insurance industry, and therefore, on the ability of individual Americans to access quality, affordable health care. And today, I'm announcing that the Department of Justice is suing to block both Aetna's acquisition of Humana and Anthem's acquisition of Cigna. If allowed to proceed, these mergers would fundamentally reshape the health insurance industry. They would leave much of the multi-trillion-dollar health insurance industry in the hands of just 3 mammoth insurance companies, drastically constricting competition in a number of key markets that tens of millions of Americans rely on to receive health care. Now, among other consequences, the number of health insurance options available to nationwide employers would shrink from 4 to 3. And 2 of the largest and fastest growing providers of Medicare Advantage plans, which millions of our senior citizens rely upon for crucial medical coverage, would combine into just 1. And competition would be substantially reduced for hundreds and thousands of families and individuals who buy insurance on the public exchanges established under the Affordable Care Act. Now, if these mergers were to take place, the competition among these insurers that has pushed them to provide lower premiums, higher quality care, and better benefits would be eliminated. Now, these mergers may indeed increase the profits of Aetna and Anthem, but they would do so at the expense of consumers, employers, and health professionals across the country, inflicting costs that cannot be measured in just dollars alone. Now, for most Americans, health insurance is not a luxury, but a necessity. And it ensures that every American can get the care, the procedures, and the prescriptions that they need to live healthy and productive lives. And it helps to provide economic security, peace of mind, especially for the poorest and most vulnerable among us. And in some cases, health insurance can quite literally mean the difference between life and death. And if the Big Five in this industry were to instead to become the Big Three, not only would the bank accounts of American people suffer, but the American people themselves. Now, the actions that we're taking today should serve as a reminder that the Department of Justice is committed to upholding our country's antitrust laws and safeguarding the principles of economic freedom that they were enacted to defend. And when the facts lead us to conclude that a merger will reduce competition, that it will restrict choice and harm consumers, we will not hesitate to intervene. We will not shy away from complex cases, and we will protect the interests of the American people. And at this time, I'd like to introduce Principal Deputy Associate Attorney General Bill Baer, and Bill will provide additional details on today's filing. Bill?
Thank you. Good morning. And thank you, Attorney General Lynch, for those powerful remarks, for ensuring that the public continues to benefit from competitive marketplaces. The 2 mergers we and a number of state attorneys general are challenging today involve 4 of the 5 largest health insurance companies in the country. They are unprecedented in their scope and in their scale. They put at risk the system that Americans across the country rely on to pay for their health care. They threaten to increase insurance premiums, to reduce benefits, to lower the quality of health care, and to slow innovation. These insurance companies, these 4, are already some of the largest, most sophisticated companies in the country. They are thriving. They are thriving as independent firms. They do not need these deals to survive. and consumers are entitled to benefit from their continued competition. Our investigation showed that these mergers are likely to harm competition that currently benefits seniors, working families, individuals, employers, the previously uninsured or underinsured, as well as doctors and hospitals. If allowed to proceed, these mergers would also cut off innovation and competition that American consumers otherwise would enjoy in the future. Each of these deals poses unacceptable risks to competition. Let's first look at Anthem's purchase of Cigna. Right now, half of all Americans get health insurance through their employers. For the largest, most sophisticated employers with multiple locations around the country, there are only 4 good choices, and 2 of those are Anthem and Cigna, which Anthem wants to eliminate as a rival. Similarly, for large but more regional employers, including those located in some of the biggest cities in the country, New York, Los Angeles, Atlanta, we see the same thing. Anthem and Cigna are but 2 of a handful of options for employers seeking to get health insurance for their employees. Now, Anthem's effort to buy Cigna affects both price competition and quality competition. Cigna is unique in its efforts to innovate, particularly in its efforts to collaborate with doctors and hospitals on wellness programs. They've proven popular with lots of employers and their employees. And so Anthem has had to respond. It's had to compete harder by keeping its prices down and by adopting its own innovative strategies to prevent Cigna from winning away a lot of Anthem business. Today, Anthem also competes with Cigna to sign up the doctors and hospitals needed to provide a comprehensive healthcare network. All this competition would be lost as a result of the merger. Now, Anthem claims that consumers will benefit if it becomes the 800-pound gorilla at the bargaining table, forcing cost concessions from doctors and hospitals without regard to the impact those concessions would have on the quality of medical care. The antitrust laws don't work that way. You don't get to buy a competitor, eliminate substantial competition, just to increase your bargaining leverage with healthcare providers. Allowing just one company, Anthem, to dictate how much doctors get paid and employers get charged isn't good for the doctors in the hospitals, it's not good for the employees, and it's certainly not good for hard-working Americans who rely on their employers for health insurance. Let me turn next to Aetna's effort to acquire its competitor, Humana. Our investigation showed that Aetna's acquisition of Humana would hurt seniors who rely on Medicare Advantage for their health insurance. Congress created Medicare Advantage in 1997 to provide a competitive place, a competitive-based alternative to traditional Medicare. Today, seniors in the Medicare Advantage program benefit greatly from competition between Humana and Aetna, as both companies have fought to expand enrollment and to compete in more counties across the country. This deal would eliminate Humana as a fierce competitor. That means that seniors in places like Sioux City, Iowa, or Joplin, Missouri, or Lenore, North Carolina, won't have any meaningful choices when they go to sign up for a Medicare Advantage program. And seniors in many other areas will also see their choices limited, their benefits reduced, and their premiums go up. In addition to the many problems I've just outlined, these 2 mergers both threaten to reduce competition for the many Americans who now obtain health insurance through public exchanges established by the Affordable Care Act. These 4 companies have been among the most active in offering insurance through the exchanges. In particular, families and individuals in cities like St. Louis, Denver, Jacksonville today benefit from competition between Anthem and Cigna and between Aetna and Humana to deliver access to affordable health insurance coverage. I'm talking about the average American in these cities, many previously uninsured or underinsured, who are most vulnerable to increases in insurance premium. But that risk of increased premiums is exactly the risk posed by these 2 mergers for consumers who today rely on the exchanges. Both Aetna and Anthem claim they can fix the problems these mergers cause by divesting bits and pieces of their business to much smaller, more regional insurers. But those proposed remedies are incomplete and impractical. They would not give the buyers of the divested assets the necessary tools to compete with the intensity that Cigna and Humana today provide. And they would leave consumers at risk. These are so-called solutions that we cannot accept. That's why we're asking the court today to block both mergers. Our lawsuits aim to protect the many Americans who today depend on these four health insurance for access to affordable, high-quality health care. Aetna's acquisition of Humana and Anthem's acquisition of Cigna may be a convenient shortcut to increase profits for those companies, but the antitrust laws make it absolutely clear that mergers are not lawful when they risk denying consumers the ongoing benefits of competition. I want to conclude my remarks by echoing thanks to the Attorney General, to the team of lawyers, economists, paralegals, and support staff at the Antitrust Division, and to our colleagues among the various states' Attorney General for the hard work that went into their thorough investigations into our jointly filing these lawsuits today. Thank you.
Thank you, Bill. We're happy to take questions.
I will ask, it's a little unusual to have two major mergers like this be announced at the same time, and then we have challenges announced at the same time. Do you envision these being on two separate legal tracks? I mean, part of the way you're discussing these involves this 5-3. You're talking about them in tandem. Do you envision these being litigated as one package or being on separate tracks?
Well, they were announced at the same time because of the company's decisions and their own individual efforts. We did review them at the same time. Both cases were ready at the same time. I believe we filed them as related.
Yes.
Is that correct? We filed them as related because of the impact on the industry. But they were separate investigations and they are separate cases. But I think the importance of bringing them together underscores the impact on the healthcare industry. Bill, do you want to add to that?
That's fine.
So as related cases, that means in theory they would go before the same judge who would consider them collectively?
Yes.
Okay.
Yes, procedurally that's correct.
Okay, thank you.
Yes. There was a hand on the left, this gentleman in the back.
Yes,
Gentleman in the back.
So this has kind of been framed as you're suing them and they're going to fight hard, back. But does it necessarily need to go that far? You said, Mr. Barrett said earlier that they had offered some divestitures that just weren't acceptable. But are there some remedies here that could come back into play, or does this just need to just die where it's at?
Well, I will tell you that we're always willing to engage in discussions, and for further specifics, I'll turn over to Bill.
There have been some divestiture proposals made, but we view them as inadequate, incomplete, and totally unlikely to solve the competitive problems we've identified. There are some mergers which can be solved through the divestitures. We've seen nothing to suggest that these can. In both cases, Anthem and Aetna have suggested they'll sell off small pieces of their business to smaller insurers who lack brand name in the areas of the country where the divestitures would occur. They lack the star quality ratings that are critically important to competition and success. They would rely, the buyers of these packages would have to rely on Aetna and on Anthem for ongoing services for years and years. The standard we apply is, will the status quo be preserved? Will consumers, after a divestiture, benefit from the same degree of competition that exists today? We have zero confidence that the proposals that have been made to us come close to meeting that standard.
So on that, but is there something the companies could do, put something, could they fix it in a way to get settlement?
We've seen nothing to suggest that, absolutely nothing.
Can I ask another question? You guys talked about the health exchanges. I was just wondering to what extent HHS or the White House was involved in expressing concern about the mergers, or?
The answer is no. We make law enforcement decisions on the merits, on the competition merits, and that was our focus. We interview interested parties, including companies, competitors, healthcare providers, the staff people at HHS, to make sure we understand the markets and the effect on competition, but there was no involvement at senior levels at the White House or at HHS. This is a law enforcement decision that we make on the merits.
Hi, can I ask a follow-up question on that?
Sure.
So you mentioned that you assessed that there would be impact or reduced competition in the Obamacare markets, commonly the exchanges, so to speak. Was it your view, after looking at the facts on the table here, that implementing this merger would accelerate the trends being seen in the marketplace already for insurers to exit many of those exchanges, or for the numbers of players in those exchanges to be reduced?
Thank you. Our concern was the reduction in competition, that if you eliminate all four of these folks are actively involved in the exchanges, and we would see reductions in competition in a number of states across the country. That was our concern. Companies are going to make independent decisions about what markets to enter and to leave, but consumers are entitled to the benefit of the competitors in those markets. And this merger, the reason we're seeking these two mergers, the reasons we are seeking to enjoin them, is to prevent that competition from being artificially reduced by acquisition.
Just to follow up on that, isn't there already a reduction in competition in those markets underway? So you're suggesting this would accelerate that, or there's be some delta over what the marketplace is already doing?
We have no doubt that these mergers would reduce competition over what it is today.
So, I mean, I know it's been fairly well documented that Obamacare helped spark the wave of consolidation we've seen in the insurance business. So are you saying at this stage that it's gone too far and that we should view this as, as a sign that no more consolidation will be allowed?
We look at each merger that's before us on its own merits. This time, as the Attorney General said, we have two that were on the same time frame, and we're not going to make predictions about what might happen in the future. All we can tell you is, and you'll read in our detailed complaints, why we are so concerned about the impact on consumers from these two deals that are before us.
Madam Attorney General, I actually have two questions on an unrelated matter. First, I was wondering if you saw this video out of North Miami in which a man is shot by an officer, and what your reaction was to that video. And then also last night at the convention, Newt Gingrich said that under a Trump administration there will be, quote, zero tolerance for death threats on police, and said that police don't get that, quote, respect now. Do you agree with that?
Well, with respect to the incident that occurred in North Miami, we are aware of the incident. I'm aware of the incident, and we're working with our partners in the area to gather more information about it. So yes, I am aware of it, and we're trying to gather all the facts about it so we can determine essentially how that matter will be handled or reviewed. I believe it is under review, obviously, by local authorities right now.
And you're considering looking at it from a federal standpoint?
We don't know enough about it at this point in time. Certainly there was a video of the incident that was on the news this morning, but we obviously want to gather as much information as we can so that we can make an informed decision. But yes, we are aware of that incident. And with respect to things that were said at either of the conventions, I actually don't have a comment on the political process that's undergoing right now. I leave that to the political world. But what I will say is that, as we have said repeatedly, that this Department of Justice stands firmly behind our law enforcement partners at the federal and state level in supporting them. And in reaction to some of the very troubling incidents that have occurred most recently involving a loss of life by law enforcement and by civilians, we are redoubling our efforts to provide support at the community level, at the law enforcement level. We are working directly with departments that often come to DOJ and seek assistance and seek guidance and technical training, for example. We're also working with community groups to facilitate their efforts to have a better and stronger connection with law enforcement. And I think the important goal is that as we all live in this great country, we all want to get home safely. And we are committed to doing everything we can to ensuring that. When it comes to, as I said before, these troubling incidents most recently involving law enforcement officers, we're providing support and assistance in the specific investigations as well as to the greater law enforcement community at large to deal with these issues, both in terms of the loss of life, but also in terms of the issues that will come about for those who are wounded and the survivors, and dealing with issues such as officer safety and wellness, and handling the stress and pressure that these incidents create on an entire department.
Just had one more question on this case.
Yes.
Oftentimes, you talk about innovation and the impact the merger is going to have on that. I thought it was important that it was mentioned again in the press release today, the impact it would have on innovation. And as the markets are getting more consolidated, I'm curious, how much more of a focus is innovation in your consideration of these mergers, specifically as it speaks to this? But also more.
You know, we're seeing as people want to improve quality and keep costs down, we are seeing very innovative work, particularly from Cigna and from Humana, to offer alternative ways of providing value-based care to consumers. And that innovation stimulates further competition between Aetna, Humana, Anthem, and Cigna. And so our concern, it is always a concern in antitrust enforcement about reductions in quality, but we are seeing real meaningful innovation that all four of these companies could and will pursue on their own. It's part of the reason why we're seeking these injunctions.
On the Aetna-Humana merger, does the DOJ see traditional Medicare as separate from Medicare Advantage, and if so, why is that?
Yes, we do, and that is the same position that we've taken in previous cases. There are more and more seniors who are turning to Medicare Advantage as a lower cost and higher quality health insurance solution. There are lower copays with individual Medicare Advantage. There are lower deductibles. You have additional benefits, dental, vision, and all of that is making it for some seniors a more appropriate solution and a better solution for them, and we do view those as two separate markets.
Thank you all.